No problem. The only exception to that is if it's something that benefits both the buyer and the seller, then it is your job to advocate for that. But be careful, because if they don't agree that it's just as an advantation to both parties, they might be thinking you're breaking your dual agency responsibilities. So in some situations, you need to call up a broker and ask a quick question. How would you handle this situation? Because we're practicing real estate agents, just like all of you, but we've been managing brokers at our current firm, and Michelle and I both were managing brokers at our previous firm, because we came from the same firm before. And we've got a lot of experience just by people asking questions, talking to attorneys, things of that nature. I'll give you an example though of something people miss. Let's say you have a listing, and right now it's a hot market again. I had, last listing I had was in Burnsville, had 5 offers on it, right? If one of those offers is an EXP Realty offer, dual agency kicks in. I can't advocate for any one of the 4 offers anymore, because I can't hurt the buyer who's got an offer in on the house, right? So if I'm in that situation, I got 10 offers and 1 or 2 of them are EXP Realties, which happens quite often. You no longer can advocate for any of them, because if you advocate for an offer that is for, let's say, an Edina Realty agent, because it's the highest price and best terms for what the seller wants, then you're working against the buyer who has the offer in on the property. So as long as that offer is still there and hasn't been rejected, you have to be neutral on all of that and just present the facts, ask the seller what they want to do, and move forward. Here's one of those rare occasions though. Let's say that EXP Realty offer is the best offer. Then it's in the best interest of the buyer and the seller, and you can advocate for that offer. But if it's not what you think is the best offer, you think the Edina Realty offer is better, then all of a sudden you have to be neutral. You can't be working against that other offer.
You had indicated though that if you rejected that EXP offer, so would that be a way to do it, is before you started negotiating with the rest of them for the seller to reject that current EXP offer, then you can go back to advocating.
Right, but at that point, I can't do anything that would help that seller reject that offer, because I may be working against that buyer. So I'd say, as long as this offer is in play, I have to be a dual agency situation. And if they bring up, well, let's deal with that offer first. Let's see if that's the best offer. And if it's nowhere in the range, if they bring that up, then you're okay. And I have had agents read between the lines of what I'm saying to do that, but I make sure I'm very neutral about it so that they can't come back to me later and say, or the buyer can't come back and say, well, you were working against me in this situation. You weren't being a dual agent.
So would this be a conversation you better had at, let's say, the listing appointment, kind of walk through this scenario with your seller?
Absolutely.
And then before that offer play, you could say, hey, if there was another EXP offer that's low, this is the way around that, because you're not in dual agency yet.
You're right, you're not in dual agency yet. So if you explain that during the listing appointment, and by the way, that'll make you look more knowledgeable and more experienced covering these situations up front, because that's one of the benefits of working with you, is that you tell them, I help you handle all these situations where other agents just wait until they happen. So doing as much information at the listing appointment as you possibly can is really helpful. So for example, like we have a listing form that talks about how to handle multiple offers and how to handle love letters. Now, I don't know if any of you are aware of that form, but that form's available to you. And that's something at the listing appointment help the seller determine what to do if we have multiple offers, whether I'm going to disclose multiple offers, whether I'm not going to disclose, how I'm going to disclose. Is it if they ask me, or do I just disclose to everybody automatically? Because you can't disclose multiple offers without their permission. So you have to have something in writing proving that they've said, hey, this is how you're going to handle multiple offers. Same with love letters. National Association of Realtors has stance on love letters is that we should not encourage them. We should tell our sellers the risk about them. Well, we have a section that covers that. I don't care on the buy side. It might be on my buyer side advantage to do a love letter, but on the listing side, the seller has a lot of liabilities, which also puts liability on the EXP agent. So if you cover love letters during that appointment, that we should reject them, not even give them to you, it helps. I'm going off a little bit off of dual agency, but just during the listing appointment, it's going to make you look more knowledgeable, help that seller understand that you're the right agent for that listing. back to dual agency questions though. Do we have any questions from people who are not online first, dual agency? Special situations, how to handle,
Well,
Yeah.
you said you can give them your options. So say that you didn't go over it prior in the listing appointment, and then you're in that position and they say, well, you're like, well, I can't give you advice, but your options, like if we got rid of this offer, this is what can happen. If you keep this offer, this is what will happen. Can you?
you be careful. I said,
Okay,
on that situation, you say, you know, I've got a dual agency situation because one of the 5 offers I've received is from eXp Realty. Now I represent that buyer, even though I've never met them, and I represent you. I have to be neutral on all of this. We have all these offers. We could go through them now, or we can wait till the time at the end, but I can't give you any advice as long as that offer is in play.
okay,
Okay, if I was to say, get rid of this offer, or that would be tough. Even saying something like, oh, if we deal with this offer first, which sounds a little bit more neutral, you know, it could be taken both ways. It's a little bit better.
that's great.
We could talk about, hey, maybe we should just, you know, since I represent eXp Realty buyer and you, maybe we should entertain that offer first and compare it to the other offers. That's more of a sounding like it's a benefit. You're representing the buyer and the seller's best interest in that kind of situation.
Yeah.
So I would be okay with something like that.
Is there ever a way to get written permission from either party to like disclose that dual agency information?
What
Does
do
that
you
make
mean?
sense? So like, could the buyer be like, I understand, like, I'm giving up my right for you to kind of like represent me on that side? So you can talk about price terms and motivation with the seller.
So you're talking about what's
We
called
forgot.
designated agency, and some states have designated agency.
Yeah.
In Wisconsin, anybody who's licensed in Wisconsin here, they have designated agency, and they have without designated agency, and that's like dual agency in Wisconsin. I'm talking Minnesota right now.
Yeah.
So in that kind of situation, as of right now, I've never seen that happen.
Okay,
Okay, you can always get permission to do whatever from buyer and seller to disclose.
Yeah.
Price, terms, condition, but advocating, I don't think Department of Commerce would like that, even if you were getting something signed by the seller, allowing you to advocate for one party versus the other party. Department of Commerce is. Sometimes the statute says whatever the statute says, and Department of Commerce says what they say, and if Department of Commerce says, this is what we care, we don't care what the statute says, this is what we interpret it as.
Yeah.
We just have to go with it because we don't go to up against Department of Commerce, because then they'll,
no thanks.
even if we win an issue for the Department of Commerce, they will find 10 other issues to get us on. And so like in this example, if we won an issue for the Pemberton Homes team, right?
Yeah,
Then they would look at all of your files, maybe
Yeah.
not just your file, for example.
that makes sense.
I have a question.
Yeah.
So as a listing agent, if your sellers did not agree to dual agency.
Okay.
And do you have to disclose that on your listing? Like if you're an eXp agent, don't send me offers because the seller won't agree to.
Well, I would put in the agent comments that they have not agreed to dual agency, because if they haven't agreed to dual agency, you really should have an eXp Realty agent even showing the property. Okay, because dual agency exists at the showing as well. So if you walk into an eXp Realty listing to show it, you can't offer, you know, material facts you have to disclose, right? But, so you can talk about those, but anything other that deals with opinion, you can't talk about it. So they shouldn't even really be at that appointment.
So you should mention that in
Yeah.
your remarks.
And your remarks and maybe the showing remarks.
And we
Showing
wouldn't be
time.
able to accept an offer from
No, you wouldn't.
agents.
And in that situation, if you have a buyer who's interested in the house, it's the eXp, you probably should refer them out for that property only to another agent and get a referral fee, because you still have to look out for your client's best interest, things of that nature. So figuring out some kind of relationship with a non-eXp agent would be the best.
To piggyback off of that, and we'll go to you, Nicole, but furthermore, if you are an eXp agent and you showed an eXp listing and you're filling out the feedback, correct me if I'm wrong here, you also shouldn't be responding to things like if you feel like it's overpriced. Because
Well, close,
you
okay?
are,
If
dual
you
agent.
are just responding with what your client said, which their response, not your opinion, but their response to the questions is fine. Client said the price should be X. That is okay. your opinion of price should not be answered. If it's asking what, in your opinion, should the price be higher or lower, you should not be answering that question. But comments from your client, and if there are none that your client gave, you can just put in there, don't answer any of the questions, or client opted not to answer any of the questions. You shouldn't even have to say that you're not gonna answer the question because they know it's dual agency.
Nicole?
What if you have two buyers that want to make offers on the same property?
That's a really good question. Says you treat it the same as if it was dual agency. Okay, you have to disclose to both parties that you are going to be making offers, and at that point, as soon as that second offer shows interest, you now have to be neutral with the property. You can't advocate. I've had situations where the listing agent actually had two buyers and they were all same firm. So now you've got dual agency across the board with three people, you know.
So you're representing the seller and you have two buyers.
Yes, open house, you know, can happen, right? And it's a tough situation, but yours is a little more complicated, just because when you have two buyers, you're not really thinking dual agency necessarily. But you do have to disclose to the other party that I have another interested party in this same property. I'm not going to disclose any of that information. That's going to be kept neutral. They're aware of that. Your offer is already in and being considered. If you do want to change anything with it, though, you have to let me know. I can't suggest it at this point, because now it's a tough conversation, right? Because all of a sudden, what do you mean? You can now no longer help me negotiate this? You know, especially on a buyer side of things. You know, I don't know about you guys, but when I'm representing a seller, I have a pretty good relationship with them, but with my buyers, because of the number of homes I take them to, I start to become attached to those people a lot more than I do with my sellers, just because of the period of time that I end up spending with them. And usually, you know, last couple of years, you know, writing 10, 20 offers before one gets accepted, you know, and going through that process sometimes. That answer your question?
So I had a situation over the weekend where I made an offer with one client that was contingent upon the sale of their house. The offer got rejected. And then the next day I had another buyer wanting to bring on the same property.
No dual agency in that
Right,
situation.
because the first offer, I talked to Cassie about it last night, because the seller rejected the first offer. It wasn't on the table, so I didn't have to disclose it.
That's right, you did not. At that point, it didn't matter. Now, if they said they want to rewrite,
Right,
then as soon as they say they're interested in it again, then dual agency pops back into play. Because it's not just when you write, it's actually when interest starts.
yeah,
You know, you do the showing and they say, well, I'm interested in pursuing that. And even during the showing, you kind of have to be careful about not, you can't even encourage them to write, right? Because then you're working against your other offers. You can say, do you want to write? You can encourage them to write.
Any other questions in the room before we go to the ones on chat? Okay. With the increasing chatter surrounding finding your buyer the home when it doesn't exist, so Chelsea's point, finding off-market properties. What tips do you have for navigating your obligation to a buyer and then meeting a potential seller who will sell to your buyer but possibly wants representation as well? So you first represented the seller, you located an off-market property through whatever means you did. You had the buyer representation first. Am I understanding this question correctly, Chelsea, or do you understand?
I think I understand the question. So if you have a buyer and you've got maybe a for sale by owner or something of that nature, and you've walked in, you showed them the property. Actually, before you showed the property, you did agency with that seller, right? Because the seller's not represented, they need to know their rights. And if at that point they express interest in you representing them, then at that point you need to follow up before you go any further to see if they're going to get represented or they're not going to be represented. Remember, whenever you have substantive contact, it doesn't matter, you know, the state law basically doesn't matter if you're at a party and they ask your opinion about something. As soon as you offer opinion and you're a licensee, you're supposed to pull out that agency form and have them sign here first, or stop the conversation, ask them at a different time for you to finish that conversation. You know, it's supposed to. No, it's not reality, and I don't think you're going to get in trouble for it. But that's how strict they are, and it doesn't matter if it's a tenant representation or a buyer or seller or landlord, all those types of situations. But let's go back to the question.
Yeah,
I
it
lost
was kind of
Um,
right there.
but if you're trying to navigate that situation, you want to deal with it right when you dealt with that seller. Right when you're doing agency at that time. Now, if they sound like they don't want, representation, or they're just thinking about it, it's like, well, fine. Remember, I'm representing the buyer and the buyer's best interest until we enter into an agency relationship, and you're fully representing that buyer up until the point the seller now says, I want to have representation. Of course, the buyer rep contract says dual agency is okay. Right? Next question.
When dual agency occurs during multiple offers, what responsibilities do we have to both parties to ensure correct representation? Can you elaborate what it means when both parties may not advocate for one party to the detriment of the other? I think this might have came in before. I feel like you pretty much.
Yeah,
already
I just
touched on
covered
it.
Yeah, that first one came in before. Sorry about that.
That's okay. Oh, and then you said, never mind. Yep, so you already covered that. Okay, any other questions on dual agency that you guys can think of? We get this
Hey,
a lot.
Cass, I've got one. It's Jen. Can you hear me?
Yep, we can hear you.
In the case of Nicole's situation where the one buyer got rejected and now she's bringing in the second buyer, how does it work? Let's say if for some reason you have a conversation with that listing agent, but that particular buyer didn't want it, let's say it was price and that buyer didn't want to come up. And now you have the second buyer, it's okay in that case then to give that material fact to the new buyer?
Yeah, because it wasn't dual agency with the seller.
Right, you didn't owe representation to the seller because it wasn't
Right.
EXP.
But what material fact are we talking about? Are we talking about?
I think she just misspoke, and not material fact, but just
Or
a,
just information, right, to help, you know, so,
You can't give information about the other buyer's offer,
right,
okay? So any of that information, unless the other buyer says, I'm not interested in that anymore, you can share that information with your other one. If you get permission, you can, but other than permission, you couldn't give any information about.
I don't think
Yeah.
she means the other buyer, I think she means, let's say the seller would have countered back and said, well, we want 450 instead of the 435.
yes.
You don't represent the seller, so yes, I would say you could share that with the
Yeah,
second
The
buyer,
seller's
because,
counter, you can't. You
Right.
can't, if the counter happened from the buy side, you could not.
Yeah, okay, that's what I want to check. Thank you.
I want to touch back on love letters. So you spoke about that earlier,
Yep.
about how really the risk is more in line with the seller,
Yeah.
right? Because of fair housing and some other things. So are buyers agents not at any kind of
I
trouble
asked,
with that?
yeah.
Is it really just the seller and the listing agent, or could there be some liability on the buyer agent for submitting that letter?
it's a good question. So I've talked to the legal hotline about this, and I've also talked to David McGee, which is probably the best E&O residential attorney in the state of Minnesota. And I used to deal with him with E&O claims at my previous firm, and so I've got his direct number, and I just call and ask questions, and sometimes he speaks at state meetings for us sometimes. Both, even though National Association of Realtors stance is that we're to discourage it, it's because they feel the practice just overall isn't good for real estate. But my stance is our fiduciary responsibility, state law trumps National Association of Realtors. Okay, and that says we have to look out for the best interest of our client. And if a love letter is in our best interest of our client on the buy side, it's our responsibility to do so and advocate for it if we feel like it is. It's the seller who has the problem with, you know, if you put a picture in there, if they say, well, I just love to have a person who's gonna raise a family here. Nope, that's red flags, that they can't make a decision based on that. If they do make a decision on that reason in the favor of your buyer, so be it. Right? It's not your responsibility to make sure fair housing issues aren't covered. It's their responsibility. So if you're in the listing side, you want to make sure that doesn't happen whatsoever, because it's no different if they said somebody was black or somebody was Mexican, or they use something, you know, Latino, they use any of those terms that they might use, the married, not married. Oh, I don't want a same-sex couple in my neighborhood. Any of that stuff come up, right? Or if they say what church, you know, in the letter, they might say what church, they might say how many kids they have, they might say this familial status, marital status, religion. religious issues. All of the different 9 plus 2 more in Minnesota issues on fair housing just can't be covered. So why allow your sellers to have that risk, right? The buy side, though, if you can pull up some heartstrings and get that offer accepted, I'm perfectly fine with it. You don't want to blatantly provide information, though, that makes it look like you're trying to influence them based on a fair housing issue, right?
So if you're the listing agent and this happens, or like, let's say they have a letter in front of them, but they're like, oh, not again, like, what do you say in that moment?
Okay,
That happens?
so whenever I get an offer, first of all, at the listing appointment, I always do cover love letters. Do you want them or do you not want them? Do you give me permission in writing? That's why we have the form to reject those offers or strip the love letter from the offer. The love letter comes separate. I can strip it, just present the offer. If it's written like in the other section of the offer or an addendum to the offer or something of that nature, it doesn't happen very often, but those are unique ways. Then I would reject the offer, have them strip the language and resubmit. That's what I would do. Now, if
They are sellers that are like, yes, we will accept love letters, and then they get a love letter, and they're like, oh, gosh, I'm taking love letter.
right,
And
and as soon as they say that, then, all right, I need to have a discussion with her. This cannot be a decision based on familial status. If it is, somebody could go back, whether you're choosing somebody because you want them to have kids or you don't want them to have kids. If you choose, make a decision based on one of those, you're opening yourself up to a lawsuit. And if I know you're making the decision based on that, we have to actually step back and you no longer represent. You know?
Would it also be fair, like, if you're having this conversation, if you're having a conversation with them at the listing appointment on whether to accept love letters or not, and they said that they do want to accept them, then me as the list agent, if I got a letter that I felt like touched on these, I'd be having that conversation with them again. I know that you wanted to review love letters, but this is putting us in a really bad position from a fair housing standpoint, and I really think we should reject this and then all love letters equally, because it's putting you guys in a really bad spot for future potential liability.
Right.
So I think I would be reading them first and revisit that
Yeah,
conversation.
absolutely. And on the listing side, you want to be so careful of this situation. It's so easy for a claim to come in and they take these claims really seriously, and as they should.
Well, hold on, Jackson had a question
Okay,
first.
go ahead, Jeff.
How would anybody ever find out that they accepted an offer based upon?
Neighbors talk.
Neighbors, absolutely.
people,
The new person moves in, neighbors talk. you
Yeah,
know.
but no, I'm not saying like, so you have these offers and there's a few different love letters, and they pick one based upon something of an opinion, like family or something like that. You're not telling the buyers that they accepted their offer because of their family. That's only the sellers making that decision.
Yeah, but if the sellers made the decision, they might tell a neighbor, and a neighbor might end up finding out, or if a buyer that lost out, because we know buyers get really upset when
Yeah.
they lose outright, they make a claim, right? They might actually go and talk to the neighbors. They might try to find out information. If they feel they were wrong, that they should have got the offer, and because sometimes sellers don't take the highest price, right?
Yeah.
And if they find out that the sales price was this and their price was higher, they might go to the neighbors, they might ask questions, they might,
They might not even have to do that. They could just create a lawsuit because they can't.
We're pissed.
yeah,
They're
was a
pissed.
lot
I
of
mean,
big
you
ones
can,
last
yeah,
year.
I mean. To answer your question straightforward, there's not a whole lot of ways to prove it or how the other
Right.
buyer would find out. The buyers do, and
Well,
things
and
happen
if
and.
yeah, if they put a file, let's say it's going to Department of Commerce, file a complaint. The Department of Commerce is gonna want all of the offers submitted on that property. By the way, you have to keep offers and messages and text messages and everything for 6 years. And if you don't have all of the offers, or something happens, you're gonna lose, pretty much. So they're gonna look at all those offers, and then you're gonna have to justify, and your sellers are gonna have to justify why they accepted that offer over another offer. And if they don't believe you, there's gonna be a problem.
So we just kind of got a lot of reaction to keeping all of the offers. Does Sky Slope allow us to upload every offer we received, or is EXP got an area for all other offers that weren't accepted to be housed?
Yeah, we have an email address. It's something to the effect of Minnesota@skyslope.com. I'll find out what that actually is, but you can send in all your rejected offers, all submitted offers. If you're on the buyer side, you're supposed to keep CMAs. Buyer or seller side, you keep CMAs, any offers that you submit or receive, anything real estate related, you're supposed to keep for 6 years. That's text messages, that's emails. Technically, the broker's supposed to keep all that stuff too, but you know, that's just not.
Well, I mean, if you guys don't know, it comes, but I just saw a lot of reactions to that, so let's get that, so we can make sure we're starting, you know, if you guys aren't keeping them.
Text messages from every.
Yeah, and if you don't, Department of Commerce, if a claim comes against you, you don't have the documentation. They're gonna look very negatively on that. You're probably gonna lose.
What if you put in the agent remarks that you're not accepting love letters? Does that put you not at risk? Because if you're not gonna go, if you're not gonna show anything like that, you're basically just going off the offers. Do
Yeah.
you still, I mean, do they have any proofs? It says
So,
right there that you're not gonna accept.
I do encourage you on listings to put that you're not accepting love letters if that's what your client wants.
Yeah.
Right? There will be aware that there are agents getting creative. They are going during the showings.
Yeah.
And they leave a love letter behind. You know, and then it's really tough for a seller not to pick up that love letter and read it.
Yeah, well,
So,
Jennifer,
So I've been trying to keep like all my phone calls and texts and emails and follow-up box under the contact. Is there a way to put like any of the offers we get or any way to see?
if you're keeping a follow-up boss, it should be fine, because we then have record of that, and we have access to follow-up boss. I'm just saying one or the other, either, it's not everybody on the team is as diligent as you are about keeping everything within follow-up boss. So I think this was more just an announcement of either make sure you're keeping it in our CRM, or let's use this platform just to make sure you're keeping proper record retention. Angie, did you have another question?
So we were talking about an idea, so the love letter thing is a way you can prevent problems. Maybe if the sellers are like, yes, we'll accept love letters, you get love letters. When you get to the, you know, presenting multiple offers or whatever situation, could you say to the seller, okay, we have love letters in front of us. I don't need to know, I don't need to know anything about what you think about these love letters, just tell me which offer you want to choose.
yeah, you surely can. And if you're not, there's no EXP agent involved, right? And you still are advocating for your client's best interest, but it can have anything. I have my
But to
discussion.
prevent the issue of them choosing for a.
I think the point is you can't then prove that you didn't read that letter. How are you gonna, you had that in your inbox. How are you ever gonna prove that you didn't read that letter and know the
Right.
content that it included?
Right, in the
If you
form,
don't know, like, if you never know, oh, they really wanted a family, and if you never heard those words.
You're not- right. you gotta,
Yeah.
you have to prove that, right? But one of the benefits of that form that we have, that talks about love letters, is if they choose they want love letters, it says, it holds you and if you're really harmless, which helps.
Yeah.
And it also helps Department of Commerce or whatever governing authority is gonna look at this situation or a lawsuit that happens. To look at that you actually took the steps to discourage, and that we recommend that you don't take love letters. And if you have those words, you know, if they say, well, they told me not to tell them what they thought of these letters, you know. Commerce might not look at that favorably, like you're trying to avoid the situation, right? I would just have the discussion, we cannot make the decision about this, based on it. Well, what am I gonna tell my neighbor? I actually had that happen to me 2 years ago, and I go like, I don't care what you tell your neighbors, you blame it on me, I don't care, but law says we have to follow this, so I'm only gonna give you this information. We talked about love letters, you said you don't wanna see them, and I am not gonna report back to you the information I know of that's not relevant to the transaction about me. When I was at my previous firm, I actually had a buyer who was waiting outside the house to do an inspection. They got there a little early and the sellers were still there. He said, well, no, the sellers are still there and they're willing to let you in, you know, it's fine if you go in. I said, I can't go in. And I said, why not? And they said, well, I'm African American. I said, well, no, don't worry about it. Welcome to Minnesota. It's not going to be an issue or whatever. And they did. And that seller called the agent not their own agent, but they called our agent up and said, this isn't gonna work, and they already had an accepted agreement, and was just absolutely crazy. And when we went back to him and said, you need to talk to your agent right away, and this cannot happen. If you pursue this, you're opening yourself to legal issues, but you need to talk to your client, probably an attorney, or your agent and an attorney right away about this situation. That buyer ended up, because we reported back to the buyer what happened, that buyer ended up saying, you know what, I don't want to cause a problem, I'm just gonna back up. It should have never happened. It should have never happened in that kind of situation. So I don't like buyers and sellers meeting for any reason, just because you never know what's gonna happen. You know, even at the closing table, that's why I kind of like this, where they close separately a lot now, because if they never meet, these issues don't happen.
Yeah. Hypothetically, you have a dual agent situation and one is claiming that they feel like you're looking out for the other's best interest. Does it sound familiar, anybody in the room? They feel like because you're, the seller says, respond to them this way, you respond to the buyer, you're giving just facts.
Yeah.
But then one is starting to say, I feel like you're representing one side over the other. How do you handle that?
Well, one of the things I like is I try to get my clients in a dual agency situation to give me instructions in writing. If you get it in writing, it's a lot easier to defend yourself, okay? And if you feel like you've got a situation where dual agency is not being, like you're doing everything right and you feel like the other party's advocating and they're seeing things like my client and my buyer, by the way, it should be the client, our client,
Yeah.
the client, the seller, the buyer, that kind of situation. Because all of, by the way, in email format, that could be subpoenaed and you were in a dual agency situation where you're making it sound like you were advocating for one party over the other. But if it's happening, and you bring it up to them and it still seems like it's happening, get a broker involved. Broker will assess the situation on both sides. We'll call both agents up. A lot of times Michelle and I will play good cop or bad cop, or sometimes I'll take one person and she'll take another person and we'll cover these situations. Because it really becomes, it becomes rocky in many situations, because, it's hard not to advocate for somebody you have known now and you start to become really close with, not advocate. And they don't understand why you can't advocate. You can explain it to them, but even if they understand it, they don't like it. And I'll give you an example, and this has happened several times. So buyer writes an offer, EXP agent, EXP. So it's a dual agency situation. They write an offer. The seller counters the offer back to the buyer. Okay, the buyer or the agent who is in contact with the buyer gives it to the buyer and discusses it and explains everything. The buyer signs the offer, hands it to the agent in contact with the buyer. The seller gets another offer and withdraws the offer before this offer was emailed to the agent in contact with the seller. What happens? Anybody know? We have to have conveyance, right? What is the definition of conveyance? If they give it, do they have to give it to the agent in contact with the seller? No, you don't, because they both represent the seller. They could give it to any agent, all 1,500 agents in Minnesota. They could give it to the broker, they could give it to the EXP agent down the road. That was doing an open house, they give it to any agent and it has been delivered. Yes. Delivery is when your agent receives it.
And everybody within EXP represents the broker.
Correct, represents the seller and represents the buyer in a dual agency situation.
How would that work for a cancellation?
Same thing. When delivery happens is when the agent, an EXP licensee who represents, which is everybody, represents the buyer or the seller. Once that fully executed document is delivered to any EXP agent, it is conveyed. Once conveyance happens, that's done.
When you're talking about getting, like communication for advocating and writing from some of the buyers, so they don't feel that you're going hard for one versus the other.
Yeah.
What verbiage are you having them sign, or are you just talking about like the initial dual agency saying that they agree to it?
Yeah.
Or is
well,
there additional verbiage you're talking?
Yeah, I talk to them when I'm explaining to the agency what it means. And then I go into some examples sometimes of what happens, but you can't cover every situation. But when I get an offer from an EXP agent, we're countering. I explain to them that, hey, they sign this and give it to their agent. They don't even have to give it to me. So if their agent has it, then that's conveyance. And so even if we get another offer in the meantime, you know, once that other agent has it. So it'd be great if the agent in contact with the buyer did it through Authentisign, and then we have a date and time. But if it's a wet signature, how do you know the agent didn't run over there when they found that you rejected the offer and got a signature, right? You don't, you have to. Right. Well, it happens. We had wet signatures where this situation happened, and it became a big situation. You talk to, you know, the legal hotline and attorneys about the situation, and it is quite clear that any agent who's a licensee that represents the party, which is everybody, it's conveyed. And so that kind of situation, you can understand where the seller's really upset because they just got an offer that's $20,000 more than this other offer that they were going to accept. And now they say, I sent the rejection in, but the other agent said, oh, but I already have it. Before the email hit my inbox, I have an Authentisign that was dated earlier. That's going to make the seller really upset. It's going to make them more upset if there's no timestamp and they say they received it. I just hadn't got back to you yet. So I went to showings. I met with them, got the signature, was on showings all afternoon. You sent me the rejection or the withdrawal of your counteroffer. And
Rejection, I thought that was just.
well, like anytime you counter, you're rejecting the original offer and you're making a brand new offer.
But you don't, there's not like a formal rejection.
No, you can just do it by email. I don't like the phone call version because there's no proof. A text, at least you have something in writing showing that it was.
And then I delete the agent.
Yeah.
Okay.
So we've talked about all the negatives about dual agency. Do you have anything positive to speak of dual agency for a client's perspective? when
Well, if
discussing
you're
that?
personally representing both sides, there's an obvious benefit financially to you if that happens, but there isn't a whole benefit. It's just much more risk, much more being careful about the situation. People think that, oh, it's an agent from your firm, so you want that offer to go through, and you're like, no, this is much more difficult for me. I actually want to charge more on it.
Yes.
If I could, because it is more stressful, there's more legal liability to me, and I have to be more careful and dot every I and cross every T. Because I'll tell you, Michelle may not be this way, but when I've got my realtor hat on and I'm going out practicing my residential real estate, not so much with commercial, but residential, I make all the mistakes you guys make. And my assistant sees the same thing, and my transaction coordinator brings it to me and said, Andy, and this, and this, fix it, okay? And then I look at the file and I go like, oh, okay, I guess I need to pay more attention. So I do all the same mistakes you guys do. So I understand what it's like to be a regular real estate agent. But when I've got my broker hat on, I'm very good at catching all the little mistakes and things that should be corrected. And a lot of times I will look at the commission and see who's getting the commission, because they're all under Parker, and see who the other agent is, and I'll call you up just to educate you. And it's not meant to be a police officer or anything, it's just to help you understand why this is a better way of doing things. So that to keep you out of trouble, because my ultimate goal is, one is to keep you out of trouble, because your license is really important to you. And then that also helps keep EXP out of trouble. Then I want, my next goal is to get paid on time. If you don't have the paperwork, you don't get paid on time. So we want to make sure that that happens. And then just help you grow your business, be there for you. That's our job. We don't recruit as brokers. That's not our job. You know, you go to a different firm, you know, a lot of the brokers, they're spending all their time trying to recruit. You know, you guys do the recruiting for us. We don't have to worry about that. We're just here to support you as agents in the company.
Okay, we just have a few more minutes before the team meeting. Anything else, dual agency? Parker?
Andy, so you're holding an open house representing a seller. Unrepresented buyer walks in, start talking. They say, hey, Andy, you seem like a nice guy. We want to buy the house. Since you're getting both sides, we cut your commission. How do you handle that?
Okay, so it's not a dual agency situation.
Yeah.
Right? Because they haven't, you've gone through agency with them, they've chosen not to do dual agency. They're representing themselves and say, you know, if you want to put an offer on the table, you know, let's get it in writing. I'll bring it to my seller and we'll discuss. and then we'll counter back to you. So at that point, I don't necessarily listen to them. As far as I kind of deflect the commission issue, I just say, let's get an offer on the table, we'll bring it to them. Sometimes, personally, sometimes I have done that in the past. I'm less likely now to do that where I've actually reduced my commission. But I also, the commission discussion, I usually try to have with my seller and the seller side as well, because that's part of their offer. Now, agent to agent, we can't talk about make a condition, commission to be a condition of a purchase agreement. You never write commission and do a purchase agreement unless when you're dealing with your agents in that kind of situation. But I try to hold firm that, I'm helping you bring a buyer to that property. Okay, if it was another agent, we would be paying that out. Would you want me to have the same benefit that another person is? Otherwise, what's the benefit for me to bring a buyer to you? So there should be some benefit there, and usually people bring, like a seller will bring that up early on in that situation. And a seller will say, hey, I want to reduce commission if I bring the buyer as a seller, or if you are representing them, I want to get the commission. And sometimes I'll do that to get the listing appointment. Usually I give a little bit of a discount, but not as much as I used to. In Parker's situation, I usually just try to get the offer in place with their idea in place. And also, we'll talk about it on the seller side. I don't make any commission adjustments unless I talk to my seller first. And a lot of times the seller will take the offer and I keep the whole commission, and that's the preferable way of handling it. I don't know if you have any team requirements.
No, it's a tricky one that I think everyone can handle differently, so I want to get your perspective.
Yeah, as an agent on my own side, I do it sometimes, I don't do it other times, it depends. If they go to any other house, they're probably just need to feel like they're getting a deal. There are some people that they have to feel like they're getting a deal somehow. And as long as you can present it to them without lying to them, because your job is to represent your client's best interest all the way up to the line, as much as you can be as comfortable as possible, you've got to represent them. You just can't cross over the line. You can't lie. You can let them believe what they want to believe, but you can't lie, across the board. So
I think one point you just made is
Yeah.
something that's good to end on too, is that our representation with buyer and seller ends.
as soon as the purchase agreement closes, when it's a move-in date, like on new construction or on a new construction is a little different though. If you have a closing for the lot, the listing agreement ends and the buyer rep agreement ends. And then if they improve and build a house on it, our listing agreement, even if you wrote a new listing agreement or a new buyer rep agreement, it says about buying a house or buying a piece of property, but not buying the improvements of the land. So you actually need a different, I don't know if you have one, Parker, or not, but you actually need a different representation agreement for improvement to a piece of land.
Next one, quick. So you're representing a buyer. In inspection period.
Yeah.
Listing agents goes to you, they're not responding to you at all.
Yeah.
Sent over your amendment already.
Yeah.
11:59 is coming.
Yeah.
It's 8 o'clock, 9 o'clock. I think this is just good for everybody to hear, but how are you handling that as we get closer to that deadline?
Okay, you have to have a discussion with your buyer and you say, hey, look, is this a deal breaker? If it's a deal breaker, I need to know because I need to send that cancellation form before 11:59 to them to cancel this or protect you. If it's not a deal breaker, we can try to get them to sign or take their word that they're going to sign it or something of that nature. And because once you send that cancellation, the cancellation is dead unless the first agreement is reaffirmed. So you send the cancellation off to protect your client before 11:59 in most cases. If they say, Andy, I just want it, but if they don't give it to me, I'm fine. We're just gonna move forward, just try to get it, but if you can't, then don't send the cancellation. But if you send the cancellation and then they do ultimately sign the amendment, you want them to add that we reaffirm the purchase agreement. And the cancellation that we sent is invalid. Because if you don't reaffirm it, it was actually canceled, and you can't amend the contract that's already canceled unless you reaffirm the original contract.
Do you have to send a cancellation form or can, I thought on the PA it says it has to be in written, like.
Yeah, you can send
if
it,
don't
you can
sign
send,
it, send it.
matter of fact, your point is well taken. I usually send the cancellation form and I write a note that this is your notice that we are we intend to cancel the first grade.
Well, both parties have to sign it for cancellation to be in effect.
It depends on the situation. If I have to read back on the inspection contingency section on here, but I think it might say if the buyer determines that this first agreement is canceled or determines that they want to cancel this first agreement, this first agreement is canceled. And some parts of the purchase agreement, like the financing section, say that, and the buyer sale contingency says that. In other areas, it doesn't say that. But it depends on what it says. Right. On the inspection one, I'm not sure if it says it's canceled or not.
Okay.
And then you still have to, even if you don't get a cancellation, then you still have to deal with what to do with earnest money, even if it is canceled. And sometimes it's small claims court, sometimes it's district court, sometimes a statutory cancellation will work, but if they contest it, then you start all over and get to district court, all kinds of problems when that happens.
Okay, we're at 12:01. We need to start the team meeting.
Okay?
Thank you very much
Thank
for
you.
coming. You're welcome to stay and have pizza with us if you'd like.
Call me
Parker,
anytime with questions. I'm always available for you guys.
thanks, Andy.